All right, everyone, it is top of the hour. So we will go ahead and get started. Before I hand it over to our presenters today, we do have just a few announcements for you. All of our phone lines have been muted, so if you do have any questions, please feel free to use the Q&A box located on the menu bar, or you can use the chat feature. Any question that needs immediate assistance, I will go ahead and answer. Otherwise, all questions relating to the presentation will just hang on to the end. As a reminder, this webinar is not for CPE credit. So thank you for joining. And now we're going to turn it over to Jay and Lisa.
Well, hello. I guess you guys can hear me. Am I good? I've never done one of these before, so let's see. So anyways, welcome to our help session for 2020. I think we did one earlier in the year. And the help was for healthcare, education, leadership training, or leadership program. Some cute little term we came up with years and years ago. So we've been doing this for about 20 years. And I just want to talk for just about 2 minutes here, and then I'll turn it over to Lisa. But just thank you for giving up your time. We know it's not easy. You got a lot of demands on your time as administrators around the country. We've been doing these within our office for about 20 years, about 5 of these sessions a year, various topics. And we're in a whole new paradigm now. So I'm going to miss the lunches we had and the raffles. And I know some of you, that's the only reason you came before, but we do appreciate you giving up the time without the prize that you're going to be taking home. So we've done a variety of topics. We're excited about this one on contracting for administrators. We try to tailor the programs directly for the administrators that are running practices, and that will bleed into some others. I know we have a lot of people that are here from hospital systems that are running practices as well, so this will be applicable to them. One big change that you'll see is the header on this. For those of you that are familiar with HMWC, over the years you're probably aware that in July 19th we merged with Eide Bailly, a nationwide firm, and so we've got a lot prettier colors. We're now blue, and looks like yellow or gold as opposed to our dark green, so some things we're getting used to. But we've got the same team here at that HMWC staff is still here, and we've got a whole lot more resources pulling in the Eide Bailly team from around the country that we've already been able to bring in to help with certain projects already in this short period of time, so we're excited about that. So I'm Jay Wickham. I'm the head of the healthcare division here at Eide Bailly in the Tustin office, and part of the healthcare team across the country as well. So I just want to pass this off to Lisa, who's going to give a little more introduction and introduce our speaker. So thank you.
Okay, thanks, Jay. Yes, my name is Lisa Young, and I'm a senior manager in our Eide Bailly, Tustin, California office. I oversee our healthcare services department, where we provide a variety of accounting and consulting services to clients in the healthcare industry. And for many of our clients, we are the outsourced accounting department for them and provide services on a daily basis, from bill pay to payroll, physician compensation calculations, and a variety of consulting. And we customize our services to fit the needs of each client and can provide as much or little assistance as needed. We work closely with practice administrators and know that you all wear many hats, and so therefore we like to provide these training sessions for you. Our presentation today will be providing tips on reviewing contracts, and our guest speaker is Kathy Nichols, who is an attorney who specializes in the healthcare industry and has been a great resource for many of our clients. So I will turn it now over to you, Kathy.
Thank you, Lisa. Thanks for the opportunity, Lisa and Jay, and the whole team at Eide Bailly for putting this together. I appreciate the opportunity to speak with administrators. I deal with administrators like you on a frequent basis because a lot of times the physicians and the providers are busy doing what they do best. So I work really well with administrators, and I'm happy to do this. Let's see.
Click on the presentation. No, okay, hold on. Trying again. Ready? click one more time. There you go.
Okay. All right. Thank you. Hopefully that was our technical snafu we got out of the way. So I'm a healthcare attorney, as Lisa mentioned. I've just got a disclaimer here that, you know, some legalese to start off the presentation, but just that, you know, I'm not providing legal advice to you specifically. Always have to talk offline with anyone, but like Lisa mentioned, tips is kind of a great way to explain what I'm trying to convey to you. Some helpful information because a lot of these topics we could spend, you know, a whole day on. So, but I know we have other things to do. But yes, so my firm, Carlson Jayakumar, we're a boutique employment and healthcare law firm in Newport Beach, California. I'm a healthcare attorney and I represent providers, hospitals, medical practices, and other providers in a variety of things such as licensing board disputes, Medicare and billing audits, physician employment agreements, hospital operations and risk management. So all kind of listed there. And a little bit about me, as Lisa mentioned, I'm a healthcare attorney, and this, we kind of already went over this, but that's what I do. So on to the presentation. So here's just sort of an agenda. And the way I kind of put this together was what comes across an administrator's desk. Hopefully not all these things every day, but probably pretty frequently you're coming across a lot of these issues. And so I'm going to highlight each one and provide you some information to help you, you know, identify legal issues and of course provide better administration and risk management for your employers, for your physicians. So the first one, employment and ownership. So provider employment agreements, most employees are what is termed at will, which basically means you can be let go at any time. So I would say most people in the workforce, that describes how their position works. Some people have a contract. So the contract will indicate how long the employment is, which is that term and termination there. So I've listed just some common contract provisions to look for when you're bringing on a new physician, if you're offering a contract. A lot of times first you'd offer an offer letter, which would have the benefits and the compensation, possibly the term. And then when you put together the agreement, a lot of times practices and hospitals have form agreements, but it's always a good idea to, you know, take a look at those every once in a while because laws change, the industry changes. And so you want to be a lookout on these that I've highlighted, but I'll just mention a couple. So as I mentioned, most employees are at will, but a provider of, especially a physician, will have what is called an employment agreement. And the reason for that is to comply with federal and state fraud and abuse laws. So a lot of times documenting the relationship, because physician compensation is so highly regulated, documenting that relationship is the best way to be compliant. So that's why you'll see a physician having an agreement, whereas other types of employees don't. And as the first one I sort of mentioned, term and termination. So the term is how long it is. For physician agreements, a 1-year term is the minimum. And that's generally what most are when you're bringing someone new on. But the one I kind of wanted to point out for administrators is the termination provision. So when it's time for the physician to leave, whether that's on good or bad terms, that termination clause ends up being pretty important because it'll dictate typically how much notice the physician has to provide you, the practice, or the group when they're going to leave. And so I've seen anywhere from 30 days is really short. Usually it's more like 60, 90, but I have seen some that are 6 months. So you'd have to know 6 months. And if the physician tries to do that shorter, a lot of times there's other provisions that allow the practice to be compensated for that. So there's like a buyout that the physician would have to pay to end it early, which sometimes the new places they're going will pay that. But you just want to make sure you know that if the physician is leaving, they're providing the sufficient notice, and make sure your contracts have that notice built in. And then the same thing you want to have if the physician is leaving for cause. So if there's an issue where they need to be terminated, usually you'd have an agreement that lets the practice do that immediately without any type of notice, so you don't have to wait, because of course there could be some safety issue or something. So that's an important one. And the other one would be the malpractice insurance coverage. In particular, what I've seen a lot of for tail coverage. And if you don't know what that is, that's where it's an extended claims period. So most malpractice insurance is claims made policies. And so you have tail coverage. When the physician leaves, they can still get a claim, even though the policy is no longer in effect because they've left, right? And so you need to have that tail coverage in place. So I've seen in the industry, in my experience, sometimes the employer pays it, sometimes they don't. So when I'm advising physician clients, I always make sure they know to look at that provision, because if the employer doesn't cover it when they leave, could be a really huge expense that the new employer may not be taking over, depending on how long they've been at the practice. So if they've been at your practice for many years, they're going to have a very long period of time they could have claims. So I would just caution the administrators just to take a look at that and see if that's even in the agreement. If it's not in the agreement, that's also not a good idea, because then it's kind of left up to interpretation. So I think you want to know either way whether or not that's something that the employer, that your practice or your group wants to pay for. But again, a lot of these contracts, it's not one size fits all. Depending on the type of practice, the specialty, there may be other provisions that are more important. And then to kind of run through, I've kind of put together just the do and do not, and I won't list all of these because you can see them, but again, the notice provisions, that's an important one because it helps determine, when the deal's done. Down at the bottom, there is do consider a non-solicitation provision, and then don't include a non-competition provision. And this is a question I get asked a lot. What is the difference between these two? So, and I know we're not all in California, and that's where I practice, but in California, non-compete clauses are generally illegal. There's some very few exceptions, which actually apply sometimes in healthcare settings, but the non-compete basically states that when a provider, so not necessarily a physician, it could be any provider or employee for that matter, when they leave, they aren't allowed to be employed in the same type of business within a certain radius. So in a place like Southern California where we are, that's really problematic. Even if it's like a 5-mile radius, it could make it so that person can't work. So that's kind of the public policy reasoning behind that. Whereas on the other hand, a non-solicitation clause means that when the employee leaves, they cannot solicit employees or patients to come with them. And there are a host of lots of litigation that keeps lawyers busy because a lot of times when employees leave, they want to bring other employees with them, whether it's staff, whether it's physicians. I've had cases where the physician leaving takes it upon themselves just to give notice to all of their patients. The patients belong to the practice. So in healthcare, it's a little bit tricky because if a patient wants to stay with their physician, they of course are allowed to do that. But where the administrators come in is making sure that the patients get notice of where their physician's going, but it's a matter of who's going to convey that notice. And I always advise practices that they should be the ones doing that. And a lot of times we build that into the employment agreement, or we're going to talk about shareholder agreements next. We could build it into that so that when the time comes for the physician to leave, which it happens, you've got it all laid out on what is supposed to happen. Because I've just handled many cases where there's been disputes about who gets the notice, what is it supposed to say? It can't say I'm leaving this horrible practice that is the most awful place to practice medicine and I'm going to this new place. It can't say anything like that. It has to be neutral, and usually you want it to be agreed upon. But that is one thing to keep an eye out on these employment agreements. Is if you have a non-solicitation clause, I would strongly recommend, because that protects the practice. And then the non-compete. What I advise, I'll give you one tip on the physician side. What I advise physicians is, since it's not really enforceable, I would advise a physician, go ahead and negotiate the other terms that are more important to you, because they can't enforce the non-compete anyways, except for very rare circumstances where if you have an small ownership interest. So those are just some that I've laid out. Another big one, and it's kind of in capital letters there, use a fixed pay that's set out in advance. And again, that's compliance with the federal and state fraud and abuse laws. So a physician can't be paid based on how many patients they see. That would be problematic. And then the other type of agreement that you've probably come across are shareholder agreements. And so this is when you're onboarding a new physician. So a shareholder agreement is the documentation of stock ownership. So they're going to be an owner in the practice. Typically that's restricted to licensed professionals. In California, we have a statute where physicians can partner with other types of providers. So it's what's called a multidisciplinary practice. So I'm sure a lot of you are familiar with that term. So it's not necessarily bring on a physician. You could bring on an owner acupuncturist or an owner registered nurse or some other licensee, but the same rules apply. And so the thing to keep an eye out for these is that you usually would have an employment agreement as well, because you want their employment with the practice to be a condition of them being a shareholder. Typically, you could have some instances where they're not, but usually you want the shareholder qualifications to be that the person is licensed, that they're an employee, that they are they have privileges at certain hospitals, that they're credentialed appropriately. That way, if you have an issue where a physician gets into trouble either with their license or they lose privileges at a hospital, the practice can say, okay, you've breached the shareholder agreement, we're allowed to remove you as a shareholder. So it's a pretty extreme remedy, but you want to have these agreements built in place basically to protect any kind of transition like that. And likewise, the rights and responsibilities, the shareholder agreement's going to lay all of that out. And then the buyout would be when the physician leaves and how that transaction works. You don't want the physician leaving or, for example, if they have a disability or if they die, what happens? You don't want those shares just to go to their family, who may not be physicians or may not be providers or have any interest in the practice. So you would have that all laid out in the shareholder agreement. And you can also have like I said, there's some limited instances where you can have the non-competition for the owner to not go and open up shop next door and compete with you. You can build that into the shareholder agreement. So that's a very narrow exception for physicians. It usually doesn't apply to other providers. And another thing for administrators to be aware of is when you onboard a new physician, a lot of times you need to amend, the shareholder, the shareholder agreement. So you'd have an amendment. So for example, if you have two shareholders and you bring on a third, then you'd amend the whole thing because you're splitting up the shares with those three. And then you'd have to make sure you've updated any corporate filings if you have any of those to do. So that's on those employment and ownership. Another issue that I know is really important is medical privacy, and I've noted HIPAA and in California's Confidentiality of Medical Information Act, and most states have their own sort of Medical Privacy Act. HIPAA pretty much swallows up most of those because it pretty much has so much more teeth than the state laws. So that's normally the guidepost that most of us follow. But the agreements that administrators probably come across are what are called business associate agreements. And before we kind of jump into those, the HIPAA, which is the federal medical privacy law, it applies to covered entities. And so those are a health plan, a healthcare clearinghouse, and a healthcare provider who electronically transmit healthcare information for certain types of transactions. So a lot of people I just wanted to point that out because it doesn't cover everyone, right? So I'm a healthcare lawyer. I'm not a covered entity. So if I have medical records, now we'll get into why I have possession of those, but if I just have those, I don't necessarily have to comply with HIPAA. But if I'm a business associate of a covered entity, which I am because I'm usually doing work on behalf of a covered entity, then my firm also has to comply with HIPAA. And then the practice that I'm working for has to make sure that I have that business associate agreement in place. And so it's both on the covered entity has the obligation, and then the business associate has the obligation. So in these business associate agreements, I always recommend, for most practices, you can put together one, and a healthcare lawyer can help you put that together. You can put together one that you can use with all of your different vendors, because that's where it's going to come up, is when you are providing medical records, not even medical records, just private health information or PHI to a vendor or another professional who's doing work for you. So there's very, very limited exceptions where if you're providing the information like pursuant to a subpoena, or the police have a search warrant, there's limited exceptions that don't really apply to what we're talking about here. But the business associate agreement that you need to have in place needs to have all of the permitted and required PHI uses, a description of the appropriate safeguards to prevent inappropriate use or disclosure. Basically, what you, the covered entity, are doing is making sure that the business associate, if they do something where they have a breach, you, the covered entity, don't take on that liability, because now this agreement says, hey, you, business associate, you're responsible. If you mess up, you have to fix it, because basically these agreements are in place, or they're needed because there's notice of breach requirements under this law. And basically what that means is, as I'm sure many of you know, is if you have a breach, you have to notify the patients, right? So if your system gets hacked, and again, it depends on how many and the extent of, and again, that's why we could have a whole educational course on that. But suffice to say is that there are these notice of breach requirements. And so you want to make sure that your business associates are taking on that responsibility, because if not, then you, the covered entity, are bringing that on. And so here's just kind of a chart that explains some examples, and the one I'll just highlight with the attorney as the business associate there is, if my client's an ophthalmologist and they provide me medical records for whatever reason, some work that I'm doing for them, I've got to have a business associate agreement in place. If I then need and this has happened before, where if I needed a transcription service to transcribe something maybe to another language for whatever reason, I had to have these letters to a patient put into Spanish, because we just needed to send something in Spanish. And so I contracted with a transcription service. So I would need a business associate agreement with that subcontractor. So we've got two there in that, with the subcontractor too. So, and that's to protect me, the business associate. But one way to go around that is, and this is what I did, is I de-identified the private health information. So I just took off the patient's name, basically. And so that's another way to kind of remember, if it's not providing a whole bunch of medical records that your lawyer needs to review for something, that you just need to have the BAA in place. But if it's providing something, say for that example, to a transcription service to just transcribe a letter for you, you could just take off the patient's name, and then you don't need to worry about complying with the BAA requirement. So just a little tip there. Medical records, we're all very familiar with those. I know, especially for hospital clients, they have policies on what a record constitutes. And I think that's really a good thing for practices to think about too, because when you get these records requests or subpoena or something for medical records, what is the medical record? A lot of us think of, okay, it's what the provider typed up or wrote down. But what about communications with patients? What about the privacy notice you have to have in place? So there's all of these other things that, may or may not constitute a medical record. So it's a good idea to think about that. But administrators probably come across the requirement to provide copies to patients, which in California, there's a 15-day requirement to do that. And then physicians are the ones that usually can get in trouble if they don't provide the records. So I've come across that many times where the patient asks for the records, they don't get them, they complain to the medical board then reaches out to the physician and says, you better do this or we're going to start investigating this, which is never a good idea. So, and you can have a fee for that as well. It just kind of depends. I've seen anywhere from like $15 to $25, and that's just sort of the administrative fee for that. Obviously, if it's excessive, you're going to get complaints. I can, as you probably know, a lot of these patients and consumers are getting very savvy with complaining to regulatory bodies because they know that then they turn around and reach out to the practice and start investigating. So, and I mentioned the privacy notice. That's another requirement of HIPAA. So you want to make sure that you get those, at the time of the first service encounter. The reason why I mention this is if the practice or the physician or group gets audited, and you can be audited either by the Office of Civil Rights with the Department of Health and Human Services is the entity that enforces HIPAA. So HIPAA has gone in and done audits to see if you have these privacy notices. And the other one is if just an insurance company audits you, which is much more likely. This privacy notice should be in whatever records you provide so that they know that their members are getting these privacy notices. So, and I know there's been some relaxation with this rule with the pandemic. I know that it applies for Medicare providers that you can sort of, do this later or it's waived for a certain amount of time, but to the extent you can do it and get it in place, pandemic or not, it's a good idea. And the other issue with medical records that I'll mention is record retention. And the reason why this is important is, again, if you get audited and you say, oh, well, we shredded those because 2 years have gone by, they're just going to assume it's you provided service or you billed for services not rendered, which is fraud. So you don't want to get rid of these records. It's a real, as you can see from this chart, and just to explain it, it's got how many years on the bottom you need to maintain them. And then what I'm trying to convey here is there's all these different, and most of these are state. The patient prescribed a Schedule II controlled substance, I believe, is a state rule, 3 years. Workers' compensation cases, that's a California state law. You have to keep those 5 years. But basically, the ones in green, which are the California facilities and clinics, and then CMS, is that you should just keep it for the longer period if you provide those, because administratively, to know how long to keep different types of records, I think would just be a nightmare, and it would be a real liability to not retain the ones that you were supposed to retain longer. So I generally advise clients 7 to 10 years. I have had the issue where a practice closes. For example, a physician passes away and, solo physician, and then the family thought, well, can we just dump these records? No, we can't. I'm sure you've seen in the news where, I think it was a big clinic that just dumped a bunch in the dumpster. And that's a huge, HIPAA violations are by the record. And so they can quickly add up to tens, hundreds, into the millions. So yeah, just dumping them is not a good idea. You want to look and see, how long do I need to retain them? And then you have to retain them in a secure fashion. So I had a client whose father passed away, had 2 2 offices, many records. And so we, we organized to have them put into a storage facility that provided all the patient notices so the patients know where the records are. But it was a big expense, a big administrative task of doing that. So my takeaway for you all is, keep in mind that you do need to keep these. I get these questions from hospital clients a lot, like, hey, we've been holding on to these for this many years. Can we go ahead and get rid of this stuff? Usually the answer is no, it's not a good idea. And a lot of times you can, scan stuff, and as long as you've got it stored securely, you should be fine. Okay, so the next issue, and we're still talking about agreements, but I just wanted to kind of do a lay of the land here. So Payors, and I'll just go through, that there's, I know you're all familiar with these, but I just kind of wanted to do an overview of the different types of Payors out there to make a point that they all basically have different rules, right? So the private insurers, and I've just given a few examples there. And as I'm sure you know, some insurance companies are insurance companies, and some of those same insurance companies sometimes are acting as third-party administrators. So, it's a larger, employer-sponsored plan that Anthem handles, but really the insurance company is some self-insured or something like that, one of these big employers like Costco or something like that. And so for all purposes, usually everyone just refers to them as Anthem, but that's kind of the distinction there. And then federal would be Medicare. TRICARE is another example. So if you do a lot of Department of Defense work, that's who you're dealing with. TRICARE is, it's its own world. So it's very much like Medicare, but it's got, its own set of rules for providers on basically, how to submit claims and things like that. Medicare Advantage is also federal. And then the state would be Medicaid, which we have Medi-Cal in California, which is run by states, even though it's a federal program, but it's run by the states. And so that's why I put it under state. And then patients, just paying cash. It's also another payor that we come across. So I just wanted to talk about, because a lot of what I do is I help practices when they're being audited by an insurance company. So you can see from this graph for Medicare, their receivables from the public are on the rise, and the reason for that kind of lay out their sources. But the ones I want to highlight are that top one, which says provider and beneficiary overpayments. And so as many of you know, Medicare, or again, one of those other payors, they will do an audit and then they calculate an overpayment demand. And then the other one to highlight would be the civil monetary penalties and restitution. And so that comes from either not complying with the fraud and abuse laws, which I sort of touched on when we were talking about employment agreements, as well as, just billing fraud coming from audits, which can be anywhere from, the insurance company or Medicare just wants the money back, right? We paid you this much. We think we're owed that back. And usually you can come to some kind of settlement, or they take it a step further and say, well, that's also billing fraud. So now we want, the penalties that we would get under the False Claims Act. And so that's an important thing to keep an eye on. These audits are on the rise. I would say even with the pandemic, the way that you have to think it from the insurance company's perspective and Medicare is that they're investigating, they call everything fraud. So they're investigating fraud. Or the potential for fraud. And so, they take that very seriously, which they should, because we could do tons of graphs on how much people have defrauded Medicare. That's surely probably in the billions. So that's why they kind of have these systems in place. But there's been more funding for them. The government's provided more funding for them to do these fraud and abuse investigations and audits. And so that's why you've seen them on the rise. And the way they start usually is with a records request. And, as administrators, you oftentimes are the first ones to see this request. And so it's important to know how important that is, not to understate it, but these are sort of, not to scare everyone, but these are sort of the issues that are at stake when a practice is being audited. And I have lots of clients that are audited for, because they bill a lot, because they provide a lot of services. They're a successful practice. And then I also have some that, you know, kind of take advantage of different billing practices. So, but what's at stake in what I've seen, a new trend over the last few years is insurance companies and private insurance companies, is they had kind of what we would call a pay and chase model. So they just pay all these claims and then they'll turn around and audit and try and get some of the money back. But now what I've seen a lot of is that they're reviewing records, and then based on that review, they place the practice on what's called prepayment review. So I don't know how many of you are familiar with that term, but basically what that means is when the practice submits claims, they will be denied until the insurance company reviews the record and then decides to pay it or not. And so the problem with that is it basically puts a complete stop on your payments. Now, the prepayment review could be for certain types of CPT codes, but the problem is if that CPT code's paired with another code, so if one code's flagged and the other one's not, the whole claim gets flagged. And the way billing claims are done is, I'm sure you know, you can't have, you know, it's like, here's the date of service and they had these 5 services. You know, it's hard to kind of split that up. Plus, most insurance companies just flag most of the claims. And so I've been dealing with this a lot with a lot of private insurance companies. Medicare does it as well. But it takes usually months to get it sort of figured out. What does the insurance company want? Is it even legal for them to do this? It really ties up how long it takes to get claims paid. What I always call it is it's an administrative nightmare, really on both sides. So the insurance companies, they are built to pay these claims. When a claim comes in, to pay it. They're not built to do a record review when you're submitting hundreds of claims. So it really slows it all down. So that's sort of the importance of when you get a letter from an insurance company or Medicare saying, hey, we want to look at some records, you should kind of put this in the back of your mind. So that's one thing. Medical board investigation and loss of licensure, those kind of go hand in hand. So, you know, an audit can quickly turn into something way worse if there are issues with the billing. You can have payment denials. You can have your staff having to, you know, review all these claims. I would tell you with the prepayment review, your staff will be very busy putting records with claims to submit them. And then what inevitably happens is the insurance companies lose the records, deny the claim, and then you got to send the records again. So you really want to avoid the prepayment review at all costs. But yeah, the audit is just sort of a sophisticated tool. I think that insurance companies and Medicare are getting more savvy at using it more to their advantage, as opposed to what I was describing before as more of a pay and chase model. And again, here's some kind of do and don'ts. I won't run through them, but again, that first one, to take it seriously, that's basically what I was describing before. And you as the auditors almost always are the first ones to see these letters. And so unfortunately, I get a lot of phone calls where the letter was ignored, or they were untimely in responding to the records. And, you know, that just sort of gets you off on the wrong foot. The other one is providing, when you do provide the records. I had a client in a Medicare audit many years ago who had provided all the records. Medicare said, here's the patient, here's the dates of service. And so he provided just that, but he didn't look at the notice, because the notice from Medicare requesting the records said, and provide any dates of service that support those services. And so for the type of provider he was, you know, they asked for dates of service that were sort of in the middle of the treatment episode, and other dates of service sort of supported why that treatment was done. And so he didn't provide all of those. It was sort of incomplete. He provided exactly what it said, but they offered for him to provide more and he didn't. And so what ended up happening is they slapped a payment suspension on him and he wasn't paid for Medicare for 6 months, which depending on your business can be, a real problem. So I would read those notices very carefully. What are they asking for? And then again, back to my previous slide on what's in the record. What do we need to provide? Informed consent's an important thing. When that's not provided, especially Medicare, they're always looking at that and they go, well, you don't have any consent here. If you don't have consent for this procedure, that's a problem. And, for primary practices, medical practices, if you don't have surgeries going on, but you still need to have informed consent for whatever treatment you are providing. So another issue would be aware of attempts to recoup stale claims. This has happened in California. The Department of Managed Healthcare came after Anthem because Anthem was sending out these letters to providers, just form letters. They sent out probably thousands, requesting money back, doing an overpayment demand for claims that were beyond the statute of limitations. So in California, they can go back 1 year for an overpayment demand. So from when you submit the claim, they have a year to request the money back, unless it's fraud, which is 3 years. But generally it's a 1 year statute. Most states, I would say most states have some sort of limit on this. I think New York's 2 years. I think there's one state that has like 6 months. It's really short, but generally it's a year or 18 months. And so you want to be careful, especially when the insurance company is requesting records from like 6 years ago. And I've had that happen many times. And the insurance company will say, well, we're investigating fraud. And so I always, push back and say, well, based on what? Just a hunch? I mean, you have to have something, right? So, so that's an important thing to keep aware of. And then, reimburse, that last one of promptly reimburse overbilling. Some providers have professional obligations to do that, but if you notice there's been an overbilling or duplicative claim, the insurance company or Medicare usually have a process for you to resubmit that. Another takeaway that I advise a lot of my clients on is, is to not speak with investigators without counsel present, because you have to remember these investigators, and these are investigators with, I would say, private insurance companies. An investigator with Medicare is probably the Office of Inspector General. So, you probably should have a lawyer already retained by that point. But for private insurance, a lot of these investigators are sending these letters and they'll communicate with office staff and whatnot. A lot of times they'll stop in. I had one where, he's like, well, I'm just down the street. I just want to stop into, the practice. And, I said that's fine, but I will be there. And so I've gone to on-site audits where the investigators show up. And the reason why that's important, first of all, for your protection, because these are investigators. So they're not trying to figure out what the truth of what you build is. They are trying to figure out if they can get any money back. But that bottom one about forget about medical privacy, don't do that. The investigator will come and they'll say, well, let me just get behind, and because especially if you have EHR, your electronic health records, and I'll just go in and I'll punch in the patient names I'm looking for. That huge problem, because if they're from, like, let's say they're from Blue Cross Blue Shield, then they only get to look at those records. They don't get to look at your Medicare patients and vice versa. So I had an audit where Blue Cross Blue Shield in New Jersey wanted to come and look at hundreds of records, and they wouldn't give the names until the day before. They were very sneaky about it. And, so we did this on-site audit, and they really wanted to just dig into the electronic health record. And, we said, no, you gave us the list, and we will get the records and we'll print it off and we'll give it to you. Because they can't have access to a whole system. There's, too much opportunity for error, whether intentional or not, of looking at PHI from other patients. And just the exposure is enough of a liability under HIPAA. So you have to keep that in mind. And the last one I'll mention is the editing of medical records, because I recently had a client who delegated to have staff pull the records together, and the staff, for whatever reason, thought some dates were wrong or something. And so they literally whited out dates. And it was very apparent what they did. And so now we're facing a billing fraud inquiry. So, you know, I wouldn't delegate it to the staff that does the filing. I think you want to have, you know, the senior administrator involved, kind of organizing it all, and then making sure your provider who actually provided the services being involved in the audit. And so now we're kind of turning towards the end here, just going over some miscellaneous types of contracts that you administrators have coming across your desk. Billing, this is a big one, right? If you're contracting with a billing company. And so I've kind of listed some issues there. Sort of the big takeaways that I would say, you know, billing under a different provider's license. You know, if you think about it like this, I can't let anyone practice under my law license, only I can do it. It's the same thing with a provider. So when you're submitting a claim for services that Dr. Smith did under Dr. Jones' license, that's a problem. Now that bottom bullet point, incident to services, that's usually what practices are trying to do, because as many of you know, if a provider, and just to kind of step back to explain to make sure everyone's on the same page. So if a service can be provided under a physician supervision, it's usually more advantageous to have it billed under the physician, because Medicare pays, at least Medicare pays 20% more, same with the other payers. So you're missing out if you're not coding and billing that correctly. Where you can get tripped up is it truly a service that can be provided incident to, and is the physician supervising? Does that mean they need to be on site? Does it mean to be they have looked and signed off on the record? Did they need to order the services? How much supervision do they need? Of course, Medicare provides very little guidance, as do state and federal laws, on what is sufficient physician supervision. So it's a little bit tricky. I always advise, if you're going to have many claims billed as incident to services, is to get sort of have a healthcare attorney look at that and determine, okay, first of all, can the service be provided incident to? Because there's a lot of times when it can't. And so if you're billing that way, you're going to run into a big problem, because what will happen is once this audit comes along and they look at the records and they go, well, the records show that Dr. Smith was doing the services. Why was it billed under this other physician? Happens very frequently. And with multidisciplinary practices, you probably have incident to services going on. So you want to make sure you're taking appropriate advantage of that. And so, you know, and your billing company should be able to help you with that. But to you know, really make sure you're compliant, you'd want a lawyer to help out on that. And you know, Eide Bailly does billing compliance reviews, which is another really good tool to have your billing company, if you contract with one, take a look at that and evaluate, you know, however often that needs to be done, you know, and see where can we make improvements to improve upon, you know, your returns, as well as are there any problems with compliance? Because if you can, the earlier you can fix that, you know, you have less exposure. And then, you know, and like I said, with the self audit, that's a great idea. Eide Bailly does that, and can provide that sort of, you know, objective review, right? If you have your own physician doing it, it's just not the same. It's not really one of the best practices. And then, as well as kind of that bottom one, signature requirements. I had an interesting story when it comes to billing, where a practice, an acupuncture practice, had was being audited, had to send in medical records, and the medical records had just these 2 words. It said "likes Sandy," like written on a lot of the records, or liked, and it was, and the insurance company said, well, what does that mean? Is it because what they were thinking was it was another person? And so it turned out, yeah, oh, that's the massage therapist. So the problem is they weren't billing for the massage therapy. They weren't documenting it. They were providing it. And so it was just those 2 words in the record. What it meant was that the patient liked that particular massage therapist. And so I think about that, because then it turned into this, we kind of went down a rabbit hole with the insurance company on this whole other audit of like, what's this person doing? So you want to make sure you've got those last two bullet points, that you document the provider credentials, who's providing the services and what their credentials are. And then the signature requirements. So if someone's providing services, they're signing the record. And the important thing about the signature requirements is if you don't get those, and I know that's hard, everyone's busy and you're documenting and then you're moving on to the next thing, is you can sign it later, and Medicare has like specific attestation requirements where you can even do it even after you get notice of an audit and you look and you go, oh my gosh, I didn't sign all these. So I had a client that went through on her own and just signed them all, and she wrote medically necessary, as if that would make it medically necessary. So that was kind of hard to unwind that, but there's a specific way in the Medicare regs where you can fill out this form, and it's just as if you had the signature. So that's a really important thing, kind of to remind your providers, is first of all to do it, and a lot of times with EHR you can electronically sign, but just to make sure that even if you haven't, you can go back and do it, and you want all your providers to sign those. For Medicare, one thing that administrators are facing is revalidation, right? For your Medicare revalidation, when that comes up, oftentimes the provider won't really know, or they just delegate it to you as the administrator. Hey, you take care of this. I think the credentialing, either the onboarding of it or the recredentialing, is a really complex area. I know that Eide Bailly does the revalidation and the credentialing. I think it's a really wise idea to work with someone like them to do this, because the problem, and I always kind of see the other side, is if it doesn't get completed correctly from Medicare's view, right? From Medicare's view, remember that, the penalty is that you don't get paid from Medicare. And so I had a client that they were doing, it wasn't even a revalidation. They had changed the structure, corporate structure. So they didn't change, it was the same practice. Nothing changed. It was just a very minor thing. But they had to, go through PICOS, which is listed there, the internet-based, the way you would revalidate with Medicare. And they had their staff do it, and it was very challenging. She just wasn't familiar with revalidation process, and they ended up, and they had multiple chances to fix it. They still couldn't get it all the, ducks in a row, so to speak. And so they ended up with about $400,000 in unpaid Medicare claims. And so luckily we could come in and we did an appeal, and we ended up getting all those claims paid. But that's a huge loss for basically not, dotting an I or crossing a T is basically what that boiled down to. So I would urge you on some of these revalidations is to just work with a company that does that, just because that is what the penalty is. And it doesn't matter that it was this minor thing. There was nothing intentional. It's just that's the way that the system is set up. Advanced beneficiary notices, if any of you are aware what this is for Medicare, if the provider believes that Medicare may not pay for some or all the services, they can provide this advanced beneficiary notice. So it's the physician's discretion, but it's a good idea for administrators to know about this, because you're handling kind of all these forms, and a lot of times the physicians or the providers will sort of delegate this, get the ABN form, and then how often do you need it? Where I see these come in is if your practice is doing maintenance care, that's typically not covered by Medicare, depending on the type of provider, right, and what the maintenance care is. So that's something that, some of these things that are more towards not providing, acute services or treating a chronic condition or something like that. So if it's something that is believed it might not be covered, then you would provide the advanced beneficiary notice. If it's a service that's excluded from Medicare, so it's something cosmetic is an easy example, then you don't need one. So you just have to be careful that you're using it the right way. There have been instances where in Medicare audits, providers, had one every time the patient came in. Medicare doesn't like that. So there's kind of this balance of, if there's going to be a course of treatment, so you're going to come in for this many visits, you could do the ABN in the beginning, and then they come in for those visits, and then it's over. And then if they come back a few months later, you probably want to get another one. So it kind of goes by, whatever that treatment plan is, if that sort of makes sense. But it's a good idea to kind of get on the same page with your providers on implementing this so you have it in place. And the main reason is that when you submit the claim and Medicare says no, you can turn around and the patient pays. So if you don't have this ABN in place, you can't do that. You just don't get paid. So, but you want to make sure you're using it appropriately. So there's kind of some technical rules to this, but that's sort of a main overview of how those work. And then another kind of stepping away from Medicare, network agreements. So I'm sure you come across these if your providers are providing services in network. There's what's called a provider agreement, which is an agreement between the practice and the insurance company. There's not a whole lot of negotiation, right? The insurance company just says, this is our contract, and you can sign it or not sign it. So there's no negotiation, but there's several takeaways for administrators. The first one is to have a copy of the health plan's provider manual, because that agreement, most likely there's some sentence in there that says we incorporate the provider manual. So the provider manual is also part of your contract. So if it says submit the claims this way, you have to do it that way. If it says these services we cover, these we don't, that's what you're contracting for. All right. And also the rates, which are usually a schedule attached to your provider agreement. So it's important to have those handy. And to just have your provider agreements in an accessible place. I've had clients kind of on both sides, some that are very organized and they know exactly where all those are, and then others that, I haven't seen an agreement in 10 years. So then it's kind of hard if, we're trying to figure out as the lawyers, what are your rights and responsibilities, because the insurance company isn't paying your claims. That's the first document I will look at, because it most likely has some clause in it that says you provider provide services, we insurance company will pay you. And so it's important to kind of keep track of those. And the other one there is reporting any changes to a provider's personal or professional life that could raise concerns. A lot of times those agreements have requirements that if the physician loses their license or something like that, you have to notify these provider agreements. And if you don't, then you're in breach and then you get kicked out of the network. So I've seen that happen before. Same, that goes for the next one, the maintaining of credentials for the providers. Again, Eide Bailly handles that. You want to make sure that the providers have the appropriate credentialing privileges and whatnot. And that's usually a requirement in the provider agreements. So they'll build that in there. Collecting co-insurance and co-payments. This is something that, as the provider has contracted to do, the patients or the members for the insurance company, they're also obligated to do this. And so when you're not doing that, it's considered billing fraud, and the insurance companies can collect at best, they just want the money back. At worst, then you've got a billing fraud claim. So you want to make sure you're doing that. I do have clients where the type of services and the types of plans, they're really high deductible. So they've got like these huge amounts that the patients are supposed to pay. You can do a hardship waiver. I draft those for clients. And so if you have that in place, and you don't need to get like their tax returns, it's just a form like, here's, basically saying like, I can't afford to pay these, or I'll pay, $10. I can't pay the $100 or something like that. If you have those in place, that's really helpful if you are waiving those for whatever reason. So you can do it. You just have to have the documentation in place. So that's a good thing to remember. And then the claim submissions, meeting the plan's expectations, that kind of goes to the top one about the provider manual. And then out of network, I just wanted to mention, even though there's no contract, you basically have to follow many of the same rules. Although, as the top one notes there, you can charge your usual and customary charges. And so this, I've seen a trend of more providers going out of network based on reimbursement rates for in-network. You still have to collect those co-insurance. The same rule applies there. you still can be subject to prepayment review audits. The reason why I note that here is that it's a little bit more challenging for an out-of-network provider to sort of unravel that prepayment review audit because they don't have a contractual right to be paid. So you're providing these services with the understanding that the insurance company will pay you. But the prepayment review can sort of dampen that and make it more difficult. So that's just something to keep an eye out on, is that it can still happen. So you don't, the point I'm trying to make is, even if you're out of network, I would not advise ignoring an audit request or a records request from an insurance company, especially if a lot of your claims are submitted to that insurance company. So if you're out of network with, let's say, Health Net, and you have a large portion of patients that are treated or large amount of claims being paid by Health Net, you don't want to ignore their request for medical records, because if you do, then they just say, oh, we're just going to throw in prepayment review, and then you're not paid from Health Net for many months. So even if you're out of network, they can still do the same thing. And again, the provider manual, they will hold you to that even though you're not contracted with them. I always have this argument with insurance companies. They're out of network, they don't have to do that, but it's still a good idea to look at it so that you know how to, submit those claims and whatnot. And then the last one there, along the same lines of the prepayment review, special investigations, they still, investigate out of network providers. So, the tips I provided earlier about, being careful in communications with special investigators would apply also for out of network providers. And then I know we're kind of getting at the end here, office leases. There's very complex requirements to comply with federal anti-kickback provisions. I bring this up for sharing, if you're sharing space with a provider that's like not part of your group. These are a highly regulated area, but kind of a takeaway for administrators are, know when your renewal date is. A lot of times it's months before that you have to let them know if you're renewing. I mean, that's the time to negotiate. You get too close and the landlords, they know you're not going to move because it's so hard to move medical practice. So you want to be aware of when that's coming up, especially if you are planning on moving, and what kind of notice do you have to provide the landlord. But those subleases that you have with providers who are not part of your group, there are very technical documentation requirements. I've listed a lot there, but the main takeaway would be that rent cannot be taken into account the volume of referrals. And so if that provider that's subleasing space from your practice, who's not part of your practice, okay, so they're not an employee, if they're getting any referrals of patients, which oftentimes they are, because that's sort of part of why they're there, their rent can't be based on that. So I had a client who was a physician who was renting space to a psychologist or someone like that. And the psychologist was only going there maybe once or twice a week, had other offices, but was using an office space there. And they had a rental agreement, they had it in writing, but this rental space agreement was based on how many patients they saw. And so the problem with that is it's tied to the volume and value of referrals, which is sort of the heart of the anti-kickback statute. There's also the federal self-referral statute, which these statutes are, we could spend a whole day talking about them, but they're very complex, and then they have so many exceptions that they almost swallow up the rule. So usually the rule is the business arrangement has to satisfy an exception, and this is one of those, as well as the equipment leases, which changed recently. So this is a popular one if administrators are handling equipment leases. So for some of your technical equipment in medical equipment in the office, a lot of times that's by lease. And again, you want to keep track of, when does it come, if there's any kind of renewal or a buyout or something like that, figure out when that is. But from a legal perspective, these agreements also have the same technical requirements, very similar. So I've sort of set them out there. And so Medicare's kind of loosened up a little bit in the past few years on what you need to do to comply. But my takeaway would just be that most of the arrangements don't satisfy it's very hard to satisfy the exception for the equipment leases. So you want to have a healthcare attorney probably take a look and make sure that that's all compliant, so you're not having either the physicians have to comply with the self-referral law, and that's where that's a problem, and then the anti-kickback statute applies to everyone. So both of those two laws have a certain amount of teeth that make these types of arrangements pretty onerous.
All right, Kathy, perfect. So,
yeah, I was trying to turn to the last slide here.
Oh, no worries. Let me bring that back up. So we won't actually have time for questions, everyone. Sorry, we are way over on time, and I do need to get another webinar started. But with the questions we have, I will send them off to Kathy and her team.
Okay, I see. I don't see the presentation, but I see the question. So there's one is, what is the safe harbor bonus plan? Oh, can you hear me okay?
Yeah, I don't think you can hear me though. We don't have time for questions. I'm so sorry. We are quite over on time, so I will have to send you the questions, okay?
Oh, okay. So the safe harbor bonus plan is in an employment agreement. You can't. Oh.
I'm not quite sure what's going on her end, but we have a delay, guys. So thank you all so much for attending, and thank you to Kathy for presenting, and we truly appreciate it, and we hope you all have a great day. Thank you all.
Thank you.